Good evening. How's everybody doing? Let's light up the darkness. Great to be learning with you on a Sunday afternoon. Yom Rishon. Who's in the house? Paul in the Great Northwest, Melissa in Great Neck, Nancy in North Carolina, Bella in Florida, Joe in the Inland Empire, Leona in Southern Illinois, John in Maine, Bill in Mid-Missouri, Shandora in the Bronx, Sharon in New Jersey, Belle in Texas, Karen in California, Pauline in Chicagoland. Ella says shalom. Welcome, everybody. We are making our way through chapter 1 today, completing Mishna number 1, the discussion of Mishna number 1 here in Tractate Gittin, the 19th volume of the Talmud. These are generally the laws of divorce. Here, the first Mishnah in chapter 1, discussing the decree that the sages made, the rabbinic decree, that if a husband sends a bill of divorce from overseas into the land of Israel, so it's written and signed overseas, and then an agent of delivery, a messenger, brings the get to the wife in Israel, and he hands it to her in front of 2 witnesses there in Israel. But because it came from overseas, the sages decreed that the messenger must be able to state, and must in fact state, that the get was written in his presence and signed in his presence. And if he doesn't make that declaration, the get might or might not be valid, but at the very least, it's going to require ratification of the witnesses. And this is all to protect the wife. In case the husband should later come and say, I didn't write that get. She wasn't divorced from me. And if relying on the fact that she's divorced, she remarried, that second marriage would get split up. And if they had kids in that second marriage, those kids would be considered a mamzer. Very important to protect the wife with this measure, and so we have this requirement. And we've been looking at all the different nuances and permutations. Well, what is considered outside the land of Israel? And what if the get was written on a boat in the water, in a body of water in the land of Israel, near the land of Israel, etc.? And yesterday we started to compare the bill of divorce to the bill of manumission. So when slavery existed in the ancient world, so if a master freed his slave, it would be via this bill of manumission. And the bill of manumission would create a status change in the slave. He goes from being a slave to a free person. And so that document is going to have similar laws to the bill of divorce. We picked this up on page 9a, and today we'll complete our discussion of Mishnah number 1 and move into Mishnah number 2. Now, with regard to Rav Adam Bar Matana's proof that we had at the end of yesterday, this was regarding where a master said to his slave and gave him a document that says, I hereby free you and bequeath all my property to you. And then the slave shows up with this document at the court. So does he in fact become free and receive all of the master's property by virtue of this bill of manumission? And what we saw is, in terms of the document freeing the slave, that's going to have requirements similar to the bill of divorce. But in terms of the slave acquiring all of the master's property, that's going to have similar laws and nuances to a purchase agreement, right? A contract of sale, which is different than a bill of divorce or a bill of manumission. Since both actions, this contract fulfills 2 actions, freeing the slave and giving him all this property, and those kinds of actions have different requirements. The sages were saying that in some cases, so the slave becomes freed, but he doesn't receive all of the property, and why that would be. And so we continue this discussion. So did Rav Nachman actually say this, that we do not divide the statement? Meaning if there's something flawed in the bill of manumission, so then he doesn't receive all of the property. Or if there's something flawed in the bequeathal, is that a word? In the giving of the property to the slave, if there's something wrong in the wording or the lack of witnesses or the fact that witnesses haven't been ratified, etc., are we going to say that since the property didn't change hands, that also the slave was not freed? Or can we say that if, okay, half the document is flawed, we still are going to fulfill the other half of the document? This, by the way, is a very modern and relevant legal question in modern contract law. You know, that if something is wrong with one part of the contract, does that cancel the entire contract or just that provision in the contract? So, and did Rav Nachman actually say this, that we do not divide the statement, right? So if part of it is flawed, all of it is flawed. But didn't Rav Yosef bar Minyumi say that Rav Nachman said, with regard to a person on his deathbed who wrote all of his property to his slave, and afterward he recuperated and arose from his illness, he can retract his transfer of property with regard to the gift of the property to the slave, but he cannot retract his transfer with regard to the emancipation of the slave. Right, so he thought he was going to die. He's on his deathbed, and he says, I give all of my property to the slave. Now, giving all his property includes the slave himself. So what they're saying here is, if you make that statement on your deathbed, and then later you don't die, so you don't have to give away all your property, but since you made this statement that included the emancipation of the slave, that part of it stands, right? And so the slave is free. And the Gemara clarifies, he can retract the transfer of the property. Why? Because it is a gift made on his deathbed. And by rabbinic decree, no formal act of acquisition is required for a gift of this kind, as it was given based on the assumption that the owner is about to die. If he does not die, the gift is canceled. But he cannot retract the transfer with regard to the emancipation of the slave, as it has been publicized about the slave that he now has the status of a free man. And this shows that Rav Nachman accepts the principle that we divide the statement, as one portion of this document is accepted while the other part is rejected. And you can see why that would cause a problem, that if the slave becomes a free man, right? So a slave is not permitted to marry without the master's permission, and only certain kinds of people can he marry, etc. There's complicated laws about a slave becoming married. But if he became free, okay, then he's a free man like everyone else. He can marry whoever he wants. It's permitted to him. So if he thought he was free and he got married relying on this statement of the master, and then the master, survives his deathbed ordeal, and then he says, I changed my mind, okay, you can change your mind about giving away your property, because you're only doing that thinking you're going to die, but you can't change your mind having freed your slave, and you can see why. But rather, Rav Ashi said, there, where Rav Nachman ruled in accordance with the opinion of Rabbi Meir, he did not do so because he holds that we do not divide the statement, as this is not the issue in dispute. Rather, this is the reason, because it is not a document that fully severs the ownership of the slave. A bill of manumission must fully sever the bond between slave and master. Since the master left over some property which he did not give away in the previous example that we covered yesterday, and since that property that's held over might include the slave himself, the bill of manumission does not fully sever their relationship, meaning it is not a bill of manumission. However, with regard to the basic issue of whether or not we divide a single statement, Rav Nachman agrees with Rava that we do divide a statement. All right, and so one of the things that we're seeing very important, forget for a second the subject that we're talking about, but if you look at the process by which the sages are arriving at a conclusion or at a proof, they will say, okay, well, look at the result. Two sages end up in the same place. In this case, the slave is free, or in that case, the woman is divorced, or in some other case, the property was transferred. But how did they get to that result? One person might have got there because we do or we do not divide a document. Another person might have got to that same result by saying that, Canaanite slave can be freed by setting foot in Syria, and another one says he can't. right? Like, how did they arrive at that result? Very, very important. Why? Because what kind of a precedent does it set for a future case that might have similar facts to one set of reasoning and not the other? Now, the Mishnah teaches, if there are those who contest a bill of divorce, right? Now we're back to our original Mishnah, Mishnah number 1. We've been in a digression. We're back to our Mishnah. The Mishnah teaches that if there are those who contest a bill of divorce that was brought within Eretz Yisrael, within the land of Israel, where it is not necessary to state the declaration, right? Let's say that the husband was in, Sfat, and the wife was in Jerusalem, and the husband didn't want to go down to Jerusalem, or we always say up to Jerusalem, even though it's south. So he didn't want to go up to Jerusalem in order to deliver this bill of divorce personally, so he sent an agent. Now, the agent is traveling from one city within Israel to another city within Israel. So that does not trigger the requirement that the agent must declare it was written in my presence and it was signed in my presence. He doesn't have to be able to declare that, so he doesn't have to witness the writing and the signing. He can just be the mailman, as it were. So in that situation, where it was sent from one city to another within Israel, when this happens, says the Gemara, it should be that get should be ratified through the signatories. So if this man can't, if the deliverer can't make that declaration, written in my presence, signed in my presence, what the sages are saying is, okay, because the husband and the wife are both within Israel and the witnesses are available, so actually we should bring the witnesses to the Beis Din, to the rabbinic court, where the bill of divorce perhaps is going to be delivered to the wife, and we ratify the signatures, or we bring other witnesses who recognize the signatures of the witnesses on the get, and we ratify it, right? And this would teach us that, that this was Rava's original reason for saying the sages made this declaration that the agent must say was written in my presence and signed in my presence, is because the witnesses to a get written overseas won't be available, right, when the wife is handed the get in Israel. But since the get was written within Israel and delivered within Israel, so the original witnesses are available. Let's bring them to court and make sure, or at least bring witnesses who recognize those signatures and make sure that the get is a valid get. Right? So says the Gemara, it should be ratified through its signatories. And now the Gemara asks, well, this is when it was contested, right? When the get was contested, that's when you have it ratified. So the Gemara asks, how many people raise this contestation? How many people have to say there's a problem with the get for us to need to bring in the witnesses and ratify the signatures? So if we say that this contestation, right, that the challenge, let's say that if we say that this challenge to the get is by one person who claims that the bill of divorce is a forgery, but didn't Rabbi Yochanan say everyone agrees that a challenge to a document may be brought by no fewer than two people? You can't just come in willy-nilly and say that get is a forgery. You have to have two people to make that challenge for it to have some bite, for the challenge to have bite. But rather, you will say that the challenge involves two people claiming that the bill of divorce is a forgery, who are subsequently countered by two others who ratify it. Well, if so, they are 2 and 2. 2 say it's a forgery, 2 say it was legitimate. What did you see that you relied on these witnesses? Rely instead on these. How can you say that the two new witnesses, are more believable, more credible than the original two witnesses? Why does the court accept the testimony of the witnesses who ratify the bill of divorce rather than those who contest its validity? And the Gemara therefore concludes that this is referring to a case in which one person contests. However, the contestation is raised by the husband himself, who claims that the bill of divorce is a forgery. You might think we could go on in this vein, figuring out what's going on with this contestation of the get, but no. We have just concluded our discussion of Mishnah number 1. Let's see what happens with Mishnah number 2 here in chapter 1. With regard to one who brings a bill of divorce from a country overseas and he is unable to say, it was written in my presence and it was signed in my presence. Why is he unable to say that? Could be that he has been struck deaf and dumb between the time when he was asked to witness the writing and the signing and now that he's delivering it. Could be that he didn't witness the writing and the signing. At any rate, he is unable to say that. So if the bill of divorce has witnesses signed on it, it should be ratified through its signatories, the witnesses themselves, or someone who recognizes their signatures should ratify the get in the manner of typical documents. Both bills of divorce and bills of manumission, by which a slave is freed, are the same with regard to the halachas, the laws of delivering the document from the land of Israel to a country overseas, and with regard to bringing it from a country overseas to Eretz Yisrael, i.e. the agents for both types of documents must declare that it was written and signed in their presence, and their statement is accepted. And this is one of the ways in which the laws of bills of divorce are equal to the laws of bills of manumission. That's Mishnah number 2. Here comes the Gemara. The Gemara asks, what is the meaning of this statement, he is unable to say? If we say that this is referring to a deaf mute, is a deaf mute fit to bring a bill of divorce? But didn't we learn in a Mishnah, anyone is fit to serve as an agent to bring a bill of divorce to a woman except for a deaf mute, an imbecile, and a minor, all of whom may not be appointed as agents at all, as they are not intellectually competent according to halacha. We talked about a bunch of times that this is in the ancient world where they didn't have the kinds of sign language, cochlear implants, other kinds of technologies and wisdom that you could ascertain whether a deaf mute is cognitively understanding what's presented in front of him and could testify about it. So in ancient times, a deaf mute is not qualified for this kind of activity. Nor an imbecile, somebody who truly lacks mental competence, nor a minor, for obvious reasons. So anyone is fit to serve, as we learned in Mishna 23a, anyone is fit to serve as an agent to bring a bill of divorce to a woman except for a deaf mute, an imbecile, and a minor. So how could you say that a deaf mute is the one who is unable to say it was written in my presence and signed in my presence when he would be disqualified from bringing it at all? And Rav Yosef says, with what are we dealing here? This is a case where the agent gave the bill of divorce to her when he was halakhically competent to do so, but he did not manage to say it was written in my presence and it was signed in my presence before he became a deaf mute. In other words, although at the time he was appointed, he was fit to be appointed as an agent, he is currently unable to say anything. We've seen that before. Now, the Mishnah teaches that both bills of divorce and bills of manumission are the same in that the agent who brings them is required to say, it was written in my presence and it was signed in my presence. And the sages taught in 3 ways the laws of bills of divorce are equal to the laws of bills of manumission. They are equal with regard to one who delivers and one who brings, i.e. if one takes a bill of divorce or a bill of manumission to a country overseas from Eretz Yisrael, or if he brings it from overseas to Eretz Yisrael, he is required to testify that it was written and signed in his presence. Number 2, and any document that has a Samaritan witness signed on it is invalid, except for bills of divorce and bills of manumission, as Samaritan witnesses are permitted to serve as witnesses for these documents. And with regard to all documents that are produced in Gentile courts, arkaot, even though their signatories are Gentiles, they are valid, except for bills of divorce and bills of manumission. These documents are not valid when prepared by Gentiles. And according to the statement of Rabbi Meir, bills of divorce and manumission are equal in 4 ways, the 3 aforementioned laws, and also with regard to a man who says, give this bill of divorce to my wife, or give this bill of manumission to my slave. They are equal in that if he desires to retract his instruction with regard to both of these documents before they have reached the woman or the slave, he can retract. This is the statement of Rabbi Meir, right? Rabbi Meir says you can send by an agent the get. Once it reaches the woman, you cannot retract. You're divorced. But before it reaches her, you can retract. That's a minority opinion, right? The majority says that once you give that get to the agent and the agent is on his way, that's it. Right? She won't be fully divorced until she receives the get, but the husband can no longer retract. And you can see the wisdom of that in case his husband says, well, I retracted, and just my guy didn't get the message. Oh, well, too bad. She received the get, considers herself divorced, and remarried. Now, the Gemara asks, right. Okay, we'll just leave that for another day. Okay, so the Gemara asks, granted, according to the opinion of the rabbis, they state the number 3 to exclude the opinion of Rabbi Meir by emphasizing that there are only 3 ways that bills of divorce and bills of manumission are similar and not 4. However, according to the opinion of Rabbi Meir, what does the number 4 serve to exclude, right? In other words, there's 4 ways in which they're similar. So is there some other apparent similarity that is not an actual similarity according to Rabbi Meir? And the Gemara answers, yes. The sages mention this number to exclude that which was taught in a baraisa. With regard to witnesses who do not know how to sign, i.e., they do not know how to write their names. So a witness to a get is what? Is somebody who sees the husband write the get, and then he signs his name on the get, right? That I witnessed this husband write a get to his wife, and then he signs his name. What if he's unable to sign his name? Does that mean that because he's illiterate, he is disqualified from being a witness? No. With regard to witnesses who do not know how to sign, i.e., they do not know how to write their names, one tears blank paper for them. One tears blank paper for them. What does that mean? That is a sort of phrase that has it's jargon. What does it mean? It means that a stencil of their names is fashioned from blank paper and placed on the bill of divorce. And the witnesses fill in the gaps with ink so that their names appear on the document. I find that fascinating. Even in the ancient world, that they could, a person doesn't know how to sign his name, you could make a stencil for him. I mean, he has no signature, so it's not like you're copying his signature. You're creating a signature for him, and then he's going to fill in the ink through the stencil. You're going to sort of help him sign his name. It's almost like a DocuSign, if you ever use that app to sign a document, which is not your actual signature, but, holds up in court because, there's going to be a paper, I guess an electronic trail that the person in question signed his name, even though it was a digital signature that's not his real signature, and an illiterate person could do that. Although you could say, well, how could he read the email? Somebody read it to him. And here, somebody prepared the stencil for him. So an illiterate person can act as a witness. Rabban Shimon ben Gamliel said, in what case is this statement said? It is said with regard to bills of divorce. However, with regard to bills of manumission and all other documents, if the witnesses know how to read and sign, they sign. And if not, they do not sign. Okay, so at least according to Rabban Shimon ben Gamliel, you need a literate person to be a witness on all documents except a get, right? All documents including a bill of manumission. But a get, right, again, this is a leniency for women. Right? It's a leniency for women so that she can be sure that she is divorced and she can go on and remarry. Right? They're making the hurdle not overly hard for her to receive the divorce. And Rabbi Meir agrees with the opinion of Rabbi Shimon ben Gamliel that bills of divorce and bills of manumission are different with regard to this issue, and he mentioned the number 4 to exclude the possibility that the law stated by the first Tana of this Baraisa applies to both types of documents. Rather, we see a distinction between the get and the bill of manumission. Now, with regard to Rabbi Shimon ben Gamliel's statement, the Gemara asks, reading, who mentioned anything about it? Right? He said, if they know how to read and sign, they sign, and if not, they do not sign. So now the Gemara says, who brought up reading? We just said if he knows how to sign his name, or if he doesn't know how to sign his name. That's not necessarily the same as his ability to read, right? It might be that somebody can sign their name even if they can't read. Now, you might think that a witness to a written document would be good if he could read the document. You might think. Let's see. Right? So with regard to Shimon ben Gamliel's statement, the Gemara asks, reading, who mentioned anything about it? Why does Rabban Shimon ben Gamliel mention a need for the witnesses to be able to read when the discussion is about a witness who does not know how to sign? And the Gemara answers, the Baraisa is incomplete. Then this is what it is teaching. If witnesses do not know how to read, then one reads in their presence and they sign. And if they do not know how to sign, then one tears paper for them and they sign, meaning you create a little stencil for their signature. So once the Baraisa is amended, it is clear that Rabban Shimon ben Gamliel was responding to a statement of the previous Tana. Now the Gemara asks, and is there nothing else that can be added to the list of ways in which bills of divorce and bills of manumission are equal? But isn't there a case taught in the Mishna on page 13a of this tractate? If a person on his deathbed says, give this bill of divorce to my wife, or this bill of manumission to my slave, and he dies, they should not give the bill after his death. However, if he said, give 100 dinars to so-and-so and he dies, they should give it after his death. So apparently, this is another halakha in which bills of divorce and bills of manumission share equal status. Now, this is very interesting. Let's look at both cases for a second and think about it. Let's start with the bill of divorce. A guy says on his deathbed, give this get to my wife. And then he dies. So, do they give her the bill of divorce? Does she become divorced after she became a widow? No, makes no sense. She's already a widow. What sense would it make for her to then receive a divorce? Now, maybe the heirs would prefer it because maybe, they're going to inherit less if she receives a bill of divorce than if she's a widow. But, tough on the heirs. At the moment that the guy dies and she has not yet received a get, she became a widow. You can't now divorce from a dead man. You're already a widow. So it really makes no sense to deliver the get, even if it was written on the deathbed after the man actually dies. What about the bill of manumission, freeing the slave? Okay, so the slave wouldn't become free until, let's say, the slave receives the bill of manumission. I'm not even sure about that. I've not researched that law yet. Is it like a get that the woman does not become divorced until she receives the get? So likewise, is it true that a slave does not become free until he receives the bill of manumission? Not sure. But let's say that is the case. So if he says on his deathbed, free my slave, here's the bill of manumission, but it hasn't been delivered yet, and then the guy dies, so at that moment, he's no longer the owner of the slave. He's dead. Who owns the slave? His heir. Right? So it's the same as in law of inheritance. I mean, it's definitely disgusting to our ear to talk about slavery in this way in the modern era. But you have to understand this is the way the law was in ancient times when slavery was a very, very common practice. And what you find is that the slaves owned by Jews had it much better than slaves owned by anyone else in the world, and they were owned everywhere else in the world. But at any rate, you can't, that bill of manumission should not be delivered after the person dies because that's a decision to be made by his heir, right? By the oldest son or several sons who are going to divide the estate. Now the Gemara answers, when the Brisa teaches the ways in which bills of divorce and bills of manumission are equal, it is referring only to a matter that does not apply to typical documents. And it does not teach any matter that is equally applicable to all typical documents. So the Gemara explains, as Ravin sent from Eretz Yisrael in the name of Rabbi Abahu, you should know that Rabbi Elazar sent this teaching to the diaspora, i.e. Babylonia, in the name of our teacher, Rabbi Yochanan, with regard to the case of a person on his deathbed who says, write a deed of transfer and give with it 100 dinars to so-and-so, and then dies before they had the opportunity to write the document. One does not write and give the document, right? So same thing, the transfer of property, if they did not manage to make that transfer of property while he was still alive, they can't do it after he dies because the property now belongs to his heir. You can't fulfill that, even though it's a dying wish. Now, you might think that his heir will fulfill it, but that's, between the son and his father, so to speak, or the son and the soul of his father. And so one does not write and give the document. And the Gemara asks, or Rav Steinsaltz asks, why not? And the Gemara explains, perhaps he resolved to transfer these 100 dinars to him only with a deed of transfer. And a deed of transfer of property is not written after the death of the owner. And this shows that other documents are also not written after one's death, which means that this law is not specific to bills of divorce and bills of manumission. Therefore, it is not listed among the ways in which these two documents are similar. Now, you might ask, well, what if he put it in his will that he wanted certain property transferred? Well, that's the law of wills, and that's not what we're talking about here. And you should also know that the law of Yerusha, right, the laws of inheritance under halacha, under Jewish law, are not the same as the laws of inheritance under secular law. That's a huge topic and not one that we're really getting into here, but it's just worth noting that. Okay. So the Gemara raises another difficulty, but isn't there the law that both bills of divorce and bills of manumission must be written for her sake, i.e. for the sake of the particular woman or slave to whom they are given? So why isn't this law included in the list, right? That both a bill of manumission and a bill of divorce have to be written for the sake of the particular person who's going to receive it. Isn't that another way in which these laws are equal? Bills of manumission and bills of divorce. Why isn't that part of the list, how bills of manumission and bills of divorce are equal? Why isn't that law included in the list? And the Gemara comments, granted, according to the opinion of Rabbah, this is included in this statement. The two documents are similar with regard to the laws of delivering and bringing, as he maintains that this requirement to write the document for the sake of the recipient is the primary reason why agents must state that it was written and signed in their presence. However, according to the opinion of Rava, right, Rava is the one who says that the reason for the rabbinic decree that the agent of delivery must state it was written in my presence and signed in my presence is because the witnesses overseas won't be available in Eretz Yisrael, right, when the get travels over the border. According to the opinion of Rava, this is difficult because it's not really the same for bills of manumission and bills of divorce. And furthermore, both according to the opinion of Rava and according to the opinion of Rava, there is the case of bills which were written and signed while they were attached to the ground. Like, for example, the bill of divorce was written on a palm leaf on a palm tree that's still attached to the ground. And the leaf is still attached to the tree. And if you write the bill of divorce on a living leaf that's still attached to the tree, that is not a valid get. It is invalidated. And it is also invalidated for a bill of manumission. So isn't that another way in which bills of divorce and bills of manumission are equal? And the Gemara explains, when the Baraisa teaches its list, it is referring solely to issues that cause the documents to be rendered invalid by rabbinic law. It does not teach cases involving invalidation by Torah law, since these two cases, i.e. documents not written for the recipient's sake, or when they are attached to the ground, these are not valid by Torah law, right? So it's kind of, it violates an express provision in the written Torah. That's a higher level of invalidation and a very clear case of invalidation, as opposed to, rabbinic decrees that were added later to draw a fence around the Torah and protect, the woman, so she should have a valid divorce. But when you violate a rabbinic decree, that's a different category than violating a written Torah decree. So the Gemara challenges that response, this explanation. But there is the example of documents written in Gentile courts, which is an invalidation of documents that applies by Torah law, and yet the Baraisa teaches this law. And so the Gemara answers, this is referring to a bill of divorce that was given with valid witnesses who observed the transmission of a legal document, and this is in accordance with the opinion of Rabbi Elazar, who says in a Mishna on page 10b, witnesses of the transmission of a bill of divorce effect the divorce. Now, what we're talking about is when the bill of divorce is delivered to the woman. Now, the husband who is overseas, which is the case we got into with Mishna number 1, he's overseas and the woman is in Eretz Yisrael. So he writes the get in front of witnesses, and then the agent of delivery brings and gives it to the woman. But as we've seen, the agent of delivery is holding that get and who's going to have to make the statement, this was written in my presence and signed in my presence. When he hands it to the woman, that action has to be done in front of witnesses. It's not going to be the same witnesses because, the husband and the other witnesses were overseas, and now the get is being delivered in this country, in Israel. But we need 2 witnesses for that delivery. And what we're going to learn is it's that witnessed delivery that is the actual moment that she becomes divorced. Not when the husband writes the get, but when she receives it in front of witnesses. So Rabbi Elazar says in the Mishna on page 10b, witnesses of the transmission of a bill of divorce effect the divorce. So in his opinion, the effectiveness of the document depends on the witnesses who observe its transmission, not those who sign the bill of divorce. Consequently, a bill of divorce that was signed in a Gentile court is rendered invalid by rabbinic law. Now, the Gemara raises a difficulty, but from the fact that it teaches in the latter clause of the Mishnah that Rabbi Shimon says, even these bills of divorce and bills of manumission are valid. And Rabbi Zera said, Rabbi Shimon accepted the opinion of Rabbi Elazar, who said that witnesses of the transmission of the bill of divorce effect the divorce. One can learn by inference that the first Tana does not hold in accordance with the opinion of Rabbi Elazar. Instead, he holds that the witnesses who sign effect the divorce, meaning that divorce happens when the husband writes the get and witnesses see that. So, yet even so, this Tana listed the cases where bills of divorce from Gentile courts are invalidated despite the fact that they are invalid by Torah law. And by the way, so if a Jewish couple divorces, right, a Jewish couple that was married under Torah law, and then later they divorce, right? So if they get a secular divorce from a secular court, that is not a divorce according to Jewish law. They need a get, right? So that she is free to go marry another man. Now, generally speaking, much easier to get the get than to get the secular divorce, right? Because the get is really just about the divorce, right? And then they part company. The secular divorce is lawyers and property and custody and a million other things. So it's very common for a Jewish couple getting a divorce, that it takes years to get the secular divorce, but the get they can get very quickly, Something to know if you didn't know. Okay. Now, the Gemara explains, we're on 10a. We're just going to go a little further because it was a short daf, and that'll set us up for tomorrow when I'm planning to do a double daf because pages 10 and 11 are also short. We need to start catching up. We're 3 dafs behind. Now the Gemara explains, it is possible that even the first Tana holds, in accordance with the opinion of Rabbi Elazar, that the witnesses who observe its transmission effect the divorce, and he does not dispute Rabbi Shimon on this point. Instead, the difference between the first Tana and Rabbi Shimon concerns a case where the signatures on the bill of divorce are unambiguous Gentile names. And the first Tana holds that although a bill of divorce is valid, if it was transmitted in the presence of valid witnesses, there was always a concern that it might have been transmitted in the presence of the same Gentile witnesses who signed it. Therefore, it is rendered invalid by rabbinic law. Conversely, Rabbi Shimon holds that if it contained names that clearly belong to Gentiles, it can be assumed that the bill of divorce was transmitted in the presence of 2 valid witnesses, and therefore it is valid. So the Gemara raises another difficulty, but the halacha, the law of retraction, applies by Torah law. As according to the opinion of Rabbi Meir, the husband can retract his instruction to give the bill of divorce, and the master can retract his instruction to give the bill of manumission by Torah law, thereby canceling the agency of the one delivering. And yet, the Baraisa teaches it among the ways in which bills of divorce are equal to bills of manumission, and this indicates that the Tana does not distinguish between a case that applies by Torah law and one that applies by rabbinic law. I'm almost done. Questions or comments, get them in. So rather, the Gemara retracts from the previous explanation in favor of the following. When the Baraisa teaches the ways in which bills of manumission and bills of divorce are equal, it teaches only a matter that does not apply with regard to the laws of betrothal. However, it does not teach a matter that does apply with regard to the halachas of betrothal. What? Why are we bringing betrothal into this? We're comparing divorce to manumission. All of a sudden, we're finding multiple similarities between bills of divorce and bills of manumission that were not included in the list of the ways in which bills of manumission and bills of divorce are equal. And since we had extra examples that seem to equate them and yet was not included in the list of the ways in which they're equal, we're looking for some kind of a, scheme, not a scheme, but an approach that would explain why some similarities are left off the list. One idea was, well, the list only includes similarities under rabbinic law, but not under Torah law. And then we found, an explanation that contradicts that. So now they're saying, well, actually, the ways in which they're similar are the ways that do not apply in the law of betrothal, because if they do apply in the law of betrothal, it's kind of obvious and didn't need to be included in this list. Is that what they're saying? So the Gemara challenges, but retraction itself is also applicable with regard to betrothal, as one who sent a betrothal document with an agent can retract it. The Gemara says the law of agency in the case of betrothal is not the same as that of divorce, as there is a difference with regard to agency undertaken to enact a matter against the recipient's will. If one appointed an agent for a matter that the recipient does not want, for example, to betroth a woman against her will, or to free a slave against his will. And that shows you what slave in history didn't want to be freed. Answer, slaves to Jewish families in ancient times, because they had it better in that situation than they would have it once they were free and had no social support system. Because there were laws of how you could treat your slave, and they have to sleep in a proper bed, and they have to eat proper meals, and they can't be worked over hard, etc. Maybe the slave doesn't want to be freed. So you don't necessarily, you can't give, in other words, if you're going to free a slave against his will, the master can do that in person. But to deliver the bill of manumission to a slave that doesn't want to receive it could be problematic, right? So if one appointed an agent for a matter that the recipient does not want, for example, to betroth a woman against her will, or to free a slave against his will, as with regard to divorce, it is a valid agency, as a bill of divorce need not be given with the woman's consent. But with regard to betrothal, it is not a valid agency, as a woman can be betrothed only with her consent. You can't betroth a woman when she doesn't agree to it, but you can divorce a woman when she doesn't agree to it under Jewish law. Okay, that is where we'll leave off today, and let us see if you've got questions or comments. That Nina is passing over to me. Reload Google Doc. Here we go. Tom, why should anyone other than the ex-husband be permitted to contest the divorce? That's a good question, right? It's between them. So who is it that's going to stick his nose into it? Maybe the kids, right? Maybe the kids, because they are affected. Particularly, let's say in a case where they're the man's stepkids, it's her children from a previous marriage, and now, someone shows up with this bill of divorce, which is going to cut off, let's say funding, support to this wife while the husband is overseas. So if it's, and maybe it's a forgery created by like some kind of a trustee of the husband's estate who is giving the wife, support. And maybe that affects her children, and so maybe they say, wait a minute, this seems like a forgery to us. And we know, our stepfather's friends, who are, pretending to be signed on this get, well, we don't recognize those signatures. So maybe that's a situation where somebody other than the wife might contest, perhaps. Sharon, while I do understand the need for these intricate discussions, I find it disturbing that a divorce is being executed while the husband is overseas. I do understand the concerns that could lead to agunot, the stranded wife, but it seems like this is not principally the reason. I guess in this situation, like so many times, whether or not it practically happens is not as important as the underlying theory, which they're going to need to figure out whether or not it ever happens in the real world. Right, and you say you mentioned you understand the reason that leads to agunot, and that's right, like the soldier going to war, who's sending a divorce or a conditional divorce. This is your get from such and such a date. If I do not return, because I'm missing in battle, no witness is going to be able to come forward and say they saw me die. Then you're a stranded woman. But now you have this bill of divorce, a conditional bill of divorce that goes into effect if I don't return by a certain date. Right, and that is the kind of bill of divorce that does come from overseas, and the agent is going to need to declare, written in my presence and signed in my presence. But you're saying maybe there's other reasons why this could be written that is not that particular situation. And I guess the sages would probably answer, it kind of doesn't matter which situations it comes up in. If it happens that a bill of divorce comes from overseas, we want this additional layer of evidence, which is for her benefit. Leona, Sue, if a man can't write his name and doesn't read, then how can he ink a stencil with his name on it? How can he testify in the court if he doesn't even recognize his own written name? Very good. How can he testify as to what's written in the get? Because they covered that, right? The person who is illiterate, they'll read it to him. And it's going to be in a situation where we can trust that what was read to him was what was written on the document, right? Somebody didn't lie to him, right? Some kind of legal framework, where there was reason to believe that what was written was what was actually read to him. They didn't take advantage of the illiterate person. But you're saying, well, wait a minute, if he can't sign his name, how is he going to remember, days, weeks, months, who knows, years later, that inky form that he stenciled was actually done by him in that situation? I guess he would say, well, I remember, stenciling my name, and I remember that that's what it looked like. But it's a good question that you bring up. Sharon, it is not easier to get a get versus a secular divorce. Ask all the agunot whose husbands refuse to give them a get. Okay, that's a different situation. So you're saying in that, are you telling me that in those situations, because I figured in those situations, the husband doesn't want to give a get, he refuses to concede that a divorce, but you're saying she's able to get the secular divorce, probably because under secular law, a woman can get a divorce even from a husband that doesn't want to give it because she doesn't want to be in that marriage, right? So of course, in that situation, it's easier to get the secular divorce. But what I'm talking about is in a situation where the husband and wife agree, we don't want to be married anymore. It will simply take longer to finish the secular divorce than it does to finish the get, right? I'm sure there's exceptions. But in my experience, from what I've seen, and that's quite limited. I know I have I'm not a divorce lawyer. I haven't seen so many cases. I don't serve in a Beis Din. But just examples that I've been aware in my life that I've seen, often, it takes years for them to work out all the issues in a secular court. But just appearing in the Beis Din and getting the get is quicker. But that's only where they both agree that they're getting divorced, and what they can agree on is the disposition of assets. Okay, that's what I've got for us today, and with God's help, we'll be together again tomorrow night, Monday, the regular time, 6 p.m. Pacific, and God willing, we'll do a double daf. The next 2 pages are pretty short. Let's get through them both and start to catch up a little bit. We're not so far behind, just 3 pages, but let's start to catch up. Have a good night.